Okay, so hopefully everyone can see and hear me. For this lecture, we'll be talking about jury representation and jury selection, and this is part of the series of preparing for a trial. So, preparing for trial in the real world, but also hopefully this will also help with preparing for the mock trial that is on its way. Okay, so when we talk about jury representative or representation or jury selection, who actually decides in terms of verdict? Is there a difference between, let's say, a trial by jury versus a trial by judge, also known as a bench trial? You do have the right to waive your trial by jury and instead just have a judge hear the evidence and decide on the case. So defendants in criminal trials ordinarily have a jury trial, but if the opposing party consents, then they can choose to have the verdict decided by a judge. What we just said is called a bench trial. When it comes to the agreements or, say, inter-rater reliability between juries and jury verdicts and bench trial verdicts, we see agreement about 70% of the time. So rates of jury versus or jury compared to judge agreements is about 70%. And where there is disagreement, juries tend to actually be more lenient than judges. So it might be in your best interest to go ahead and go with the jury trial rather than the judge. So when it comes to the disagreements that involve or the disagreements between juries and judges, about 50% of those disagreements, the research shows, involve jury sentiments. So these are things that are beyond the evidence or the law. So when there is a disagreement, about 50% of the time, it's because the jury is relying on something other than the evidence and the law. They instead might be relying on personal experience. They might be relying on their beliefs, their emotions, who knows, other type of information, but something other than the facts of the case or what the law tells them that they should be taking into consideration. So when it comes to jury sentiments play a role in decision making when jurors believe that the crime is too trivial for the expected punishment. So jurors might think that the punishment doesn't fit the crime, so to speak. And sometimes we, saw this happen when states would institute mandatory minimum sentences. So you got caught with a certain amount of weed or cocaine, and there was an automatic mandatory minimum sentence. You must spend this much time in jail or prison. The judge can't do anything about it. Sometimes jurors would say, well, that's a very harsh punishment for this type of crime, right? For what jurors might consider a trivial crime. Juror sentiments might also play a role when jurors believe that the defendant has already been sufficiently sanctioned. So if this person has been waiting in county jail for a year, just waiting there, waiting to go to trial, if they were not able to make bond or bail, then they're spending their time in the jail. So, or if they committed a crime and they weren't getting, or they weren't offered the option for bail or bond, they would have to spend their time in jail, waiting for trial. Now, you could think about the dilemma that might raise, right? Because we're innocent until proven guilty. So this is a person who is waiting for a trial. They haven't been found guilty, yet they're incarcerated. They're spending their time in jail waiting for a trial. And if they're found not guilty, it's not like they're going to get those months or a year, maybe, or more. It's not like they're going to get that time back or even be compensated for that time. So sometimes a jury or jurors might feel that, you know what, the person might have committed the crime, but they kind of, they kind of paid for it already. And that might be because they already spent some time in jail, or because their reputation has been completely ruined. Maybe, their significant other divorced them because of this, and they lost their job because of this crime that they committed. Maybe they've kind of already paid enough for this crime that they committed. Number 3, jurors might believe that a law is unfair. So there are plenty of laws that not everybody agrees with, right? There are plenty of things that are illegal that not everybody believes that should be illegal. So jurors might decide that the law is unfair and refuse to find a defendant guilty of it, or refuse to punish that person for breaking a law that jurors think shouldn't be law, right? So that's getting back to the idea of jury nullification that we had spoken about very early in the semester. The fourth bullet point here deals with jurors might see a crime as minor or victimless. So again, kind of going back to this idea of a law being unfair, but in this case, that the law that was broken was a victimless crime, right? So a lot of people will see say prostitution as a victimless crime, and of course there's two sides to that story. Clearly, sex trafficking is a thing. It's a real thing where people are being held against their will and being forced into sex work. But there's also, another side to that where sex workers work as basically independent contractors. So Nevada is basically the only state, and only certain counties in Nevada that has legalized prostitution, and they register as independent contractors, and there's a bunch of laws and guidelines that they must follow, these sex workers. So people might see prostitution as a victimless crime, or might see drug use as a victimless crime, so they would refuse to punish someone for that. Or something like euthanasia, if somebody helped a loved one end their lives because they were in extreme pain and suffering from a terminal illness. Jurors jurors' morals might get in the way. It's getting back to this idea that the law and morality are not always the same, right? There could be some dilemmas that exist there. So jurors are more likely to return not guilty verdicts when they're impressed by the presence of a third-party defense witness. So that could be in, say, the form of an expert witness testifying on the defense's behalf or the defendant's behalf, or by the absence of a prior criminal record. So it's definitely within your favor to not have a prior criminal history. So if this is your first time around, jurors will be more likely to give you a pass, right? Because by and large, the idea of a quote unquote second chance is something that we kind of believe in as a society, that, you know, everybody messes up. So long as you didn't kill somebody or rape somebody or do something, you know, horrific or steal a whole bunch of money, most people are going to say, okay, a minor drug offense, it's the first time around, no prior criminal record. The jurors will be more likely to return a not guilty verdict. Just don't do it again, right? Because once you have a criminal record, now you're screwed. So we see that, you know, jurors' personal beliefs and their personal inclinations and politics and morality, all of that, and their experience and their knowledge, all of that stuff can come into play in terms of how they reach a decision, what kind of verdict that they return. So in civil cases, it's a little bit different. So differences appear in civil cases only in product liability and medical malpractice cases, when we talk about whether you should go with a jury trial or a bench trial, a judge. So plaintiffs tend to have more success with judges in these cases, product liability and medical malpractice. So about a 48% win rate in these cases compared to a 28% win rate with juries. So when it comes to civil cases and you have a product liability or a medical malpractice case, you should probably go with the bench trial. Now, that's of course if the person that you're suing agrees to that, right? You'll have better luck with those cases. And what might account for this? Well, it might actually be explained by a selection effect. So when we talk about selection effects, we're talking about the type of cases that actually make it to trial. Remember that in criminal cases, the vast majority, we're talking about 95 to 98% of criminal cases are going to be plea bargained, right? They're never going to make it to trial. When it comes to civil cases, the vast majority are going to be settled outside of court. So selection effect refers to the cases that actually do make it to trial. That these might be cases that are, let's say, weaker for the plaintiff. Because the defendant in civil cases, it's within their interest to just settle. That way they can avoid legal fees, which can get really expensive, and they avoid having to pay a much larger penalty or a much larger award, right, that is given by a jury. So for a defendant, most of the time it's better to just settle with the plaintiff. So it might be that the cases that actually do make it to civil court are the ones that are kind of weak for the plaintiff. These are not cases that the defendant was willing to settle. They'd rather fight this in court because they're pretty sure they're going to win. So when it comes to the selection effects, defendant lawyers tend to settle cases in which the plaintiff has a strong case. So this typically leaves juries to decide relatively weaker cases for the plaintiff. So this might explain why juries have a lower rate of favorable verdicts compared to judges, who judges are going to be much more versed in the law, and much more versed with much more familiar with different legal standards and different terms when it comes to culpability, or rather liability. Okay, so when, let's say we're going to trial, we're going to go with a jury trial, so we need to pick a jury. The jury selection begins as officials from the state or the county assemble a panel or a venue of prospective jurors. So typically this is basically anybody who has registered to vote, or if you registered for financial aid, or if you have a driver's license, then you automatically become part of this potential jury pool. And I'm sure some of you have already gotten a summons to appear for jury duty, and if you haven't, you most certainly will at some point. Now, whether you actually make it on a jury is a different story. But these are, we make up the pool of potential jurors. You just need to be a citizen, or even a permanent resident, not have any prior felonies, and be 18 years or older, and you're eligible to serve on a jury. That's it, right? So to encourage representativeness, the U.S. Supreme Court, or several U.S. Supreme Court cases since 1880, have forbidden systematic or intentional exclusion of religious, racial, and other demographic groups from jury panels. So there have been a number of cases over the last 140, 50 years or so that have forbidden people of particular group from being excluded from serving on juries. Historically, though, most juries have been made up of middle-aged, well-educated white men. That, of course, is changing, but again, we're talking historically. Those changes are somewhat more recent here. So some of the reforms that have been made in order to make juries more representative involves the jury pool from which the jury is selected must be a representative cross-section of the community. Remember, you're entitled to a jury by your peers, right? So your peers should represent, that jury should represent your peers, the people who live in your community, the people from where you are from, right? So this involves jurors being more heterogeneous, so more diverse, and also this type of representativeness actually gives more of an appearance of legitimacy to a jury. You can imagine, and it was a frequent occurrence, particularly in the South, in southern states during segregation or during Jim Crow, that a black defendant would be tried by an all-white jury. These were kind of seen as sham trials, as bullshit trials, and largely, for the most part, they were bullshit trials, right? So we want the jury to be diverse, and this representativeness also gives legitimacy to the jury and the verdict that they reach. So from those persons who are eligible for jury service, members of the jury pool are randomly selected and summoned to appear at the courthouse for jury service. That typically involves getting a notice to appear at a courthouse on a certain date at a certain time, and if you're allowed like 1 or 2 postponements, but you should not throw that summons away. You can actually be arrested if you don't show up for jury duty. It's really rare for that to happen, but it does happen. Sometimes they, want to make an example of somebody. Don't let that somebody be you. So you should show up for jury duty. It typically involves waiting around for a long time. Seeing if you are going to be called in for questioning, the voir dire process, which we'll talk about in a moment. But you definitely want to bring a book, a laptop, your phone, some homework to complete. It might be a long day, and you get paid like bullshit. You get paid like nothing. But they give you like $8 or $12 an hour or something like that. It's not a lot of money. But if you're waiting there, sometimes, depending on what number you are, when you'll be called in for questioning, sometimes you'll just wait for a few hours and then be told that you're free to go. Why? Well, because they already selected the jury, so they don't need you anymore, and you're free to go. Let's say you're a little bit earlier in the number pool, so you get called in by for voir dire. You get called in for a questioning, and it's typically by a defense attorney and an attorney for the state, a prosecutor, and they will. Well, let's take a look at the slide here, just so I don't miss anything or skip ahead. So the purpose of this type of questioning this questioning process is to determine if prospective jurors are prejudiced. So the voir dire process can be requested by either side, prosecution or defense, or the judge, and it's usually just standard practice to go through a voir dire process to at least ask potential jurors some basic type of questions. We'll see that there's different types or different levels of voir dire that can take place. So who asks the questions, what questions are asked, how they're phrased, how long these questions are going to be, or how long the questioning goes on, and whether the questions are posed to individual jurors or to a group, are all matters left to the judge's discretion. So the judge will basically decide what questions are going to be asked, how they will be asked, how many questions can be asked, and if you're going to question individual jurors or say groups of jurors as a whole. Okay, so what's actually involved? Well, there's two types of voir dire. The first is limited voir dire, and this typically involves yes or no type of questions that are asked by the judge and answered by a group of individuals. The problem with limited voir dire is that it offers very little insight. A question might be, do you feel that you are able to be objective in reaching a decision in this case? Yes or no, right? Yes. I mean, most people are going to give a socially desirable type of answer there, so it doesn't really give us a whole lot of information. Also, as we've seen, most people are unaware of their biases, right? Most people don't know that they're biased, or again, because of social desirability, they might be hesitant to express their biases or their prejudices openly. So this type of limited voir dire is pretty limited. We also have extended voir dire. Then this involves open-ended type of questions. And these open-ended questions are given or asked to jurors individually. So the purpose or the benefit of this extended voir dire is that it encourages jurors to talk more. So it gets them talking, which you're able to get more information, and you could ask follow-up questions while the juror or potential juror is talking, right? You could say, okay, that's interesting. Let me ask you this question about that thing that you just said. Also, it can result in disclosures that jurors might not otherwise offer. So what do we mean by that? Well, because we're not asking yes or no type of questions, it's easier to just give a yes or no false answer. It's much harder to give a false narrative type of open-ended answer. Also, because you're encouraging these potential jurors to talk, you might build some rapport with them and kind of get them to open up a little bit. So a typical voir dire process is going to involve a combination of both of these processes. So a limited voir dire with an extended voir dire. So basically a compromise. When I've been called for jury duty two times. One time I didn't have to go in. One time I did have to go in when I was in Brooklyn. And I was a PhD student and I was studying jury decision making at John Jay College. So I thought for sure that I was going to be dismissed, that I was going to not have to serve right as a juror. I was like, I'll just tell them I'm a PhD student that is studying legal decision making. They're not going to want me on the jury. Yeah, no, they didn't care about that. I ended up not serving on the jury, but not because I actually was studying jury decision making. It turned out that the case that I was being questioned about was a civil case that a woman was suing the city of New York. So they were suing New York City because a snowplow had hit her car, but it hit her car when she was doing some questionable driving technique. So there was some, there was some issue there. But as it turned out, through extended voir dire, it was mostly yes or no type of questions, but if you answered yes to a certain question, they would ask an open-ended follow-up question. And through that process, they discovered that I was an instructor, an adjunct instructor at Brooklyn College. So I was teaching at Brooklyn College during the time, which meant that I was an employee of the city of New York. So, because the woman was suing the city of New York, and I was an employee of the city of New York, I was let go because of potential conflict of interest. And I was like, really? So the whole thing like that, like that I literally spend 10 hours a day in a lab studying jury, that doesn't matter. Yeah, no, we don't care about that. It's just the fact that somebody from the city signed my paycheck is why I got dismissed. Okay, well, I didn't have to serve. Part of me was kind of disappointed because I'm like, I study this stuff. I want to see it like in real life, right? I want to kind of experience it. I've sat in on trial, like I've gone to courtrooms, and observed, but I was never actually part of a jury. So, part of me was disappointed about that. Part of me was also happy that I didn't have to do that or serve on that jury, because I had stuff to do. Okay, so what happened there? How did I get dismissed? Well, I got dismissed for cause, right? So there's two mechanisms by which potential jurors can be excluded from a jury. And the first is called a challenge for cause. So each side can claim that a particular juror should be excluded because they're biased. In my case, the plaintiff, the lawyer who was representing the woman suing the city, claimed that I had a potential bias because I was an employee of New York City, right? So I was released for cause, right? So you can see here having a relationship with one of the parties. So technically, I had a relationship with the defense in this case because the defense was the city of New York, and I was an employee. So each side has unlimited number of challenges for cause. So if there's good reason to dismiss a potential juror, go ahead and challenge that juror. And ultimately, if the other side agrees, then in this case, the defense wasn't going to fight the challenge. They're like, fine, let him go. Let's move on. But they could have challenged it, and then it would have been up to the judge to decide whether I should be excluded or not. And there's another process by which you can, say, remove jurors from potentially serving on the jury, or remove potential jurors. And that's through preemptory challenges. So with a preemptory challenge, each side can exclude a designated number of potential jurors without stating a reason. They don't have to give any reason. They might just not like how you look. They don't like the color of your hair, or they don't like the shoes that you're wearing, whatever. They don't have to state the reason. They just say, I want to use one of my preemptory challenges, and boom, you're gone. No reason has to be given whatsoever. Now, you're only allowed a certain number of these, and that's going to, again, be up to the judge. So the number of these preemptory challenges, or we'll say challenges without cause, are going to vary depending on the judge. Okay, so when it comes to preemptory challenges, getting rid of people without stating a reason. Why? What's the purpose of that? Why should we allow that to happen? Well, preemptory challenges serve a number of purposes. Number one, they allow attorneys to challenge potential jurors who will be unsympathetic to their client. So it might just be a matter of, yeah, I don't think this person likes my defendant, right? Or I don't think this person likes my client. Can't prove it, right? I can't state a cause as to why I think they don't like my client. So I'm just going to use a preemptory challenge to get rid of them, right? Because sometimes, you can get a feeling, sometimes you get an intuition, a hunch, might be the way they are looking at your client, right? You can't go to the judge and say, I want to challenge that, juror with cause because they looked at my client funny. Judge will say, get the hell out of here, right? What are you talking about? That's not a sufficient cause. So you can use one of your preemptory challenges to get rid of that person, to make sure they don't appear on the juror if they're staring down your client. Number two, it allows those in a lawsuit to play a role in selecting the jury. So you might be more satisfied with the outcome. This is a concept known as procedural justice. So those people who are involved in having a say in who makes it onto the jury or not might actually view the verdict as being more fair because they had a role in picking the jury. So if you have a role, if you have some kind of say in who makes it onto the jury, you're more likely to accept the verdict. Believe that the trial was more fair, be less likely to appeal the verdict. And number three, it allows the attorney to begin to indoctrinate prospective jurors and influence those who ultimately will make up the jury. So the voir dire process, number three here, can actually be used to start priming your jurors, right? The way that certain questions are asked during the voir dire process, you can start planting seeds that will later be fertilized, let's say, or sprouted during the actual trial. So whether that's good or bad, I'll leave that up to you to decide, but it's certainly a purpose. It's certainly something that preemptory challenges allow to happen, right? So when it comes to preemptory challenges, you're still not allowed to dismiss someone because of a particular group that they're in, right? So you can't just say, yeah, that person there, that's a black person. We don't want that person on the jury, but I can't say that. That's not good cause. So instead, what we're going to do is use a preemptory challenge. Okay, you can do that, but the other side might raise what's known as a Batson challenge, which means, no, hold on a second. I think you're getting rid of that juror because they're black, right? And the Supreme Court, believe it or not, took up to 1986, Batson versus Kentucky, or Batson v. Kentucky, that said that you couldn't exclude jurors based solely on race. When it came to excluding, that you're not allowed to exclude jurors based solely on gender, that took to 1994. So not a long time ago, right? So before these dates, you were able to exclude someone based solely on race or solely on gender. So when a defense attorney or a prosecution attorney, this, what I'm going to say here can go either way, but when a defense attorney believes that the prosecution's preemptory challenge was motivated by racial factors, he or she can initiate a so-called Batson challenge. And the judge is then going to ask the prosecutor or the defense, if it's the other way around, for an explanation. They're going to ask, why are you getting rid of this person, right? So, what is it about them? The prosecutor will typically advance a race-neutral explanation for the challenge, or if it's, like I said, the other way around, the defense attorney will typically give a race-neutral. They'll try to skirt around the issue and say, no, it's not about race at all. All right, it's about something else. So it's ultimately going to be up to the judge to decide whether that explanation is genuine, whether it's a valid explanation, or whether it is indeed based on race or gender, right? So you can't use your preemptory challenges to discriminate, at least not on race and gender. The other side might raise a Batson challenge, and then you're going to have to explain yourself to the judge. So that protection at least still exists. So when it comes to selecting jurors, attorneys will often use different strategies. The way that juries are picked traditionally have been picked on, has been based on just like folklore, on cliche, or on just bad information, stereotypes. That's what I'm looking for, the word. They were based largely on stereotypes and kind of like folk psychology. So if I have a female defendant, I want to make sure I get a bunch of females on the jury, right? Because that's just common sense. Well, the research says that common sense isn't so common or so sensical at times, right? So when it comes to different selection strategies, trial lawyers often apply their implicit personality theories to jury selection, again relying on stereotypes, and some of these stereotypes might be rooted in some kernels of truth. And if you remember from social psychology, most stereotypes might have a kernel of truth to them. When you go really far back, there might be something there. But the stereotype gets blown out of proportion and it gets generalized to every person in that group. But lawyers might rely on stereotypes, biases, kind of what they consider common sense. An example being that, say, blacks might be more anti-cop or less suspicious or more suspicious of police officers. So we want more black people on the jury if I'm a defendant, right? Or if I'm a defense attorney. Yeah, the research says in some cases maybe, and in other cases no, you don't, right? So again, relying on these type of stereotypes or people of certain socioeconomic groups, that poor people, let's say, have some type of implicit personality traits, or that rich people would be more inclined to rule in a certain way. These are not really rooted in any type of scientific jury selection data or jury selection studies. Another strategy that I kind of talked about here is the similarity leniency hypothesis. So the idea that, if I have a Hispanic defendant, I have a Latino male defendant, I want to pack that jury with Latinos and Latinas, right? So the research shows no, actually you don't do that, because it could actually backfire on you in what's known as the black sheep effect. The black sheep effect states that people may sanction those who reflect negatively on and embarrass the group. Right. So if you have a Latino defendant and you stack the jury with a bunch of Latino and Latina jurors, they might actually be more harsh, more punitive to the Latino defendant, because they're saying you're making us all look bad. Right? You did this crime, this is why people believe stuff about us, right? So they might actually respond more punitively. So that is not necessarily common sense. You would think, no, people are gonna favor those who are like them. Not always, right? Again, relying on these type of traditional strategies versus taking more of a scientific approach to jury selection. So we see what the research shows is that we really shouldn't be focusing on socio-demographic characteristics of people, because people are people. They're individuals, right? So if anything, we should try to determine some of these potential jurors' personality traits, because you would be very surprised when it comes to, say, different ethnic groups or racial groups. They might be, say, quote-unquote liberal in one area of the law, but be really conservative in another area of the law. So trying to lump everybody together based on where they're from or the color of their skin is not really an effective way to pick a jury. Instead, focusing on these potential personality, say, traits, or trying to phrase questions in such a way to tap into these personality traits. So research suggests that enduring aspects of one's personality, things like authoritarianism, need for cognition, extroversion, and people's attitudes may influence courtroom decisions, though usually only to a modest degree. So even somebody who is pro cop or pro prosecution, just by their nature, say more authoritarian, more about rule of law and order, even that person, their personality might affect their decision only to a modest degree. They're still going to be able to evaluate the evidence fairly and come up with, most of the time, the quote unquote correct decision, meaning that even these personality traits won't necessarily bias their decision. This is what the research shows, at least, right? So attorneys tend to overvalue the importance of demographic variables, like we said, and they tend to undervalue the importance of personality variables when they're making these preemptory challenges. So they might kick someone off the jury because of their race or gender or sexual orientation or their religion, or because they work for the city of New York, whatever the case may be. I had no allegiance to the city of New York. I can't give two shits that this person was suing the city. It would not have affected my decision in any way, right? If anything, I tend to be more in favor of people who are fighting the system. So the guy who, kicked me off might have been more inclined to side with his client. I don't know. I didn't sit through the trial. I didn't hear the evidence, but I'm saying, generally speaking, I'm tend to be for the little guy fighting, bureaucracy or fighting the system. But that guy kicked me off the jury based on a demographic variable. Stupid guy. So that tends to be the case in terms of picking jurors, when we probably should be focusing more on these personality variables. But in general, social scientists such as us, right, or such as we tend to be skeptical of how much lawyers can really accomplish during voir dire. You're gonna be able to get a personality profile from questioning someone for I filled out a questionnaire, stuck around to answer a follow-up question. I waited around for about 6 hours to spend about 15 minutes being questioned and then told to go home. So how much information are lawyers really gonna get out of the voir dire process? I don't know, right? Especially if they're using these types of stereotypes, if they're using this type of folk psychology to pick their jurors. I'm not sure they're really gonna get much out of this. So, what happens if you take a scientific approach to jury selection? First of all, what is a scientific approach to jury selection, and also does it work any better than the process that we typically use? When it comes to the scientific approach, this is a bit of a dilemma that we're faced with in the criminal justice system. Because when it comes to scientific jury selection, this involves the use of consultants, trial consultants, who will use empirically based procedures, including focus groups, shadow juries, basically mock trials, and surveys of an entire community to try to tap into potential jurors, try to tap into that pool of potential jurors to identify the qualities of desirable and undesirable jurors. Why is this a dilemma? because that costs a ton of money, a lot of money. Trial consulting is a big business. That basically, if I didn't end up as a professor taking a vow of poverty, right? As a professor, I'd be making shit double, triple, quadruple what I make now, which, you know, everything's relative. But I'd be making a lot more money as a trial consultant. So basically, this type of service or services are really only available to those who can afford it. So this is a dilemma, because only rich people really get this luxury of kind of, let's assemble a mock trial, let's present all the evidence, and then we get to question these jurors about, you know, how did you vote and why did you vote? What was the most convincing? What was the most damning? You basically get to kind of test the trial out before you actually do the trial. Okay, that's going to cost tens of thousands of dollars, if not 100 G's right there, to do that. So who can afford that? Very, very rich people, right? It also might include, just say, focus groups and say, what do you think about this, the defendant? And they might, you know, just give a summary of the evidence that is against the defendant, and the evidence that is in favor of the defendant, and just listen to people talk and try to pick up patterns and listen, ask them questions about the various aspects of the evidence, or various aspects of the defendant, him or herself, right? And you get information about that. So you might also just do a canvas of the whole community. If, you know, murder took place in Otsego County, the jury pool is going to be people who live in Otsego County. So let's find out some information about the people who live in Otsego County, because then we'll be able to tell who we should keep on the jury and who we might want to kick off the jury. So again, jury consulting is one of those areas that I don't know how I feel about, because I have a lot of friends who do it, and it's kind of, you know, we go into PhD programs to do this, to do what I do, right? I love what I do. I mean, it's still a job, right? I still would rather get a paycheck for doing nothing. But if I had to do something for money, this is definitely what it would be. Unless I could get paid for drinking whiskey and eating pizza, that might be the only thing other than this. But clearly, I like talking. I'm talking to nobody right now. So, and I'll do this for hours sometimes, right? You listen to these lectures. So when it comes to, you know, jury consulting, it's we don't, most of us, that's kind of the fallback job, and it's almost crazy to think about it as a fallback job, because it pays so much more money than what a professor at a public liberal arts college makes, you know. So, yeah, there's that. There's some ethical type of, or moral type of issues that come with this. Okay, but that aside, does it actually work? Well, there's some research that has been done. Horowitz, for example, this is 1980, so a little bit dated here. But even some of the more current research that I'm familiar with that you might actually come across in your readings for this week tend to find the same results. So they tend to be pretty reliable. They're kind of stable. But he determined that traditional methods were superior in cases in which there were weak links between demographic, personality, and attitudinal factors. So cases like murder, right? Everybody knows that murder is wrong. So it doesn't really matter what your demographics, it doesn't matter what your race is, what your gender is, whether you're rich or you're poor, doesn't matter if you're an extrovert, an introvert, if you're an authoritarian or a libertarian, murder is just wrong, right? Like, we all agree on that. So these types of scientific decision making, jury selection, is not really gonna make too much of a difference, at least according to this research, when you're dealing with cases that these things wouldn't really matter, right? Murder is murder. However, scientific methods were superior when those associations were strong. So, for example, in a drug sale case, right? So, in a drug sale case, when we're talking about something like drugs, this is where demographics might actually play a role. This is where people's attitudes towards drugs might actually matter. This is where people's personalities might actually matter, right? Just for example, I think all drugs should be legal, or at least criminalized, right? It's our bodies, we get to decide what we put in them. Who's the state to tell us what we can and can't do to our own bodies? That's my personal belief. Somebody might want to know that during a voir dire process if they want to select me for a drug sale case. Talking about a minor one. As soon as violence is involved, then you lost me, right? But I'm just talking about someone getting some coke or getting some ecstasy or something. Like, I don't give a shit about that. Like, not guilty. I don't care. But they found it on him. He admitted not guilty. Whatever, right? Like, so they might want to know that about me. But without even asking me directly how I feel about, say, drug use, there are certain things about, say, my education or about my sociodemographic information that might give them an idea of how I might feel about drug use. Okay, so basically the short answer when it comes to whether scientific jury selection is any better than this kind of traditional selection, as with most things in psychology, it depends, right? It depends on what kind of crime we're talking about here. Okay, so one other issue that we need to consider when picking a jury is the issue of pretrial publicity. So, what is pretrial publicity? Exactly what the name suggests. So this is publicity about the case that makes it into the news, makes it into social media, that makes it into conversations before the trial actually takes place. So this type of information could be prejudicial. If jurors are walking into a case having all this information that they got from the news, they might walk in already believing that a person is guilty or a person is innocent. Or they might have facts, what they think are facts of the case, that would never be allowed as evidence in a courtroom, right? So pretrial publicity is very problematic, especially if you're dealing with a very high-profile case, right? So pretrial publicity highlights tensions between two fundamental rights that are outlined in the Constitution, that are actually outlined in the first 10 amendments to the Constitution, aka the Bill of Rights, right? And the first is the freedom of press, as guaranteed by the First Amendment, and the right to a speedy and public trial before an impartial jury, as guaranteed by the Sixth Amendment. So, pretrial publicity kind of makes these two rights contentious, or we run into a problem here, right? A bit of a dilemma, or a bit of a butting of heads between these two fundamental rights. So these two rights clash. That's the word I was looking for. These two rights clash when the press publishes information that threatens the defendant's right to a trial by an impartial jury. And you have to think about the nature of pretrial publicity. And I would say the Fifth Amendment actually plays an important role here. In the Fifth Amendment, we are protected from self-incrimination, right? So we have the right to remain silent when it comes to anything that might incriminate ourselves. It's interesting, you don't have the right to remain silent about everything. That if you know that I did some crime, and I committed some crime, and you know this, and you're put on the stand, you can't plead the Fifth because you didn't commit the crime, right? You would have to rat me out or face contempt charges. So you're only protected against self-incrimination. So you can only plead the Fifth if you helped me commit that crime, or you helped me cover it up, right? So when it comes to pretrial publicity, most of the information that is making it into the news, that is being reported in the news, is coming from just one side, the prosecution. Why? Because the defense should not be saying anything, right? And a defense attorney who goes out there and starts flapping their mouths to the media, that's an attorney you should fire, get rid of them, right? Because as a defendant, it's up to the state to prove that you, beyond a reasonable doubt, that you committed this crime that you're being charged with. It's your responsibility to shut the fuck up. Don't say anything, right? This is what gets most people in trouble, is they start talking. So what information is making it into the media? Whatever the prosecution wants to put out there, right? Whatever the police want to put out there, whatever the victims' families want to put out there. But the defense family, they should be told to shut up. You definitely don't want your lawyer out there. You better not be out there like flapping your mouth, right? The defense needs to be quiet. So you actually get very biased coverage when it comes to pretrial publicity. You're getting what the prosecution basically has to say. If you're getting any information from the defense, it's, well, we can't comment on that, or, well, we'll let a jury decide. Anything more than that, you need a new lawyer, right? You need a different lawyer. So the point being that the information that's being put out there that potential jurors are being exposed to is inherently prejudicial. It's coming from one side, just the prosecution. So what usually ends up happening is that this notion of trial by public opinion, is that people are reading the newspapers, watching the news, going on social media, and they're learning about things that would never make it into evidence, like hearsay evidence, or information that just don't meet the federal guidelines for evidence, right? Something that a judge would never allow into the courtroom, but you're hearing it on the news because there's nothing to stop them in that regard, right? In terms of what the media is allowed to report on. So there's definitely a trial by public opinion, and the jurors are likely going to be exposed to pretty damning information about the defendant before they even step foot in a courtroom, before they even hear an opening statement or a single piece of evidence in there. So we have a couple of Supreme Court rulings that deal with pretrial publicity. And the first one comes from 1963. That says exposure to news with information strongly pointing to the defendant's guilt was a violation of due process. So essentially, the court is saying that the news should be fair or balanced. This is a 1963 ruling, and if you remember from earlier in the semester, we said that the court in the 1960s tended to be more pro-defendant rights. That changed in the 1970s and still exists today. But the courts, and particularly the Supreme Court, tends to be more pro-prosecution, pro-cop, rather than pro-defendant. So, this ruling says information strongly pointing to the defendant's guilt was violation of due process. This is why anytime you hear a news report about a crime and a defendant, you're going to hear the word allegedly, right? So, Michael Brown allegedly killed this person, right? And on the night of such and such, Michael Brown allegedly took a knife and stabbed this person 26 times. Like, put all the details in there, put all the information you want in there, but you protect your ass by saying allegedly. And if you want to get extra protection, at the end, just remind people that I'm still innocent until proven guilty. And you know, that should take care of it. People totally won't be swayed by your reporting if you say that, right? No, not so much. We have another ruling here in 1991, and the court said if prospective jurors claim that they can be impartial, defendants do not have a constitutional right to ask them about the specifics of their exposure to pretrial publicity. So all I have to do as a prospective juror is say, yeah, I can be impartial. I can be objective. And then the defense has no right to ask me about my pretrial exposure in terms of publicity. They don't get to ask me, like, have you been following this case? What do you know about this case? How often are you checking the news about this case, right? I might know everything, read every article, watched every news video, been on every message board, every chat room about this case. All I have to do is say, yeah, no, I can be objective, and then the defense has no right to ask about my exposure to pretrial publicity. So I don't know how you feel about that. All I'll say is, put yourself in the defendant's shoes. We kind of want jurors to go in there with a clean slate, right? This is the purpose of having courts and having rules of evidence and having courtroom procedures. It's because people are supposed to be relying on what happens during the trial to reach a verdict, not what they hear in the news, what they hear in the media, which is not what it used to be, right? So what are some of the effects of pretrial publicity? Is this really, a thing? Is it really something that we should be worrying about? I mean, it sounds like it should be something to worry about. It sounds kind of damning, kind of bad, but what does the research actually say? Well, in experimental studies, so when we study the effects of pretrial publicity in a laboratory or in a controlled setting, participants are either exposed or not exposed to some form of publicity, and then they're asked to assume the role of jurors in a simulated trial or in a mock trial. In field studies, this is studies actually done on real cases, community respondents, so people in the community, are surveyed to assess the effects of naturally occurring publicity about an actual case. So what do we find from both types of studies? Well, conclusions from both types of studies show that jurors exposed to pretrial publicity are more likely to favor the prosecution and prejudge the defendant as guilty. So pretrial publicity is a real thing that has real effects. So it's something that, we need to take into account if our goal is to have a fair process, to have fair trial, and to uphold the notion of due process. So why do these effects occur? Well, pretrial publicity may bias jurors' interpretations of evidence at the trial. They're already walking in with a whole bunch of information that they got from the media. So any new information, they might just process the new information in terms of the old information, or perceive the new information relative to the information that they're already walking in with. Also, jurors come to believe, wrongly, that pretrial information was presented as part of trial evidence. So this is something known as source monitoring error. So jurors can sometimes have trouble distinguishing between actual evidence and what they heard from the media, right, or what they heard in the news. So they might come to believe that no, this piece of information that is totally hearsay and would never make its way into a courtroom, no, that was definitely presented in trial. I remember hearing that during the trial. No, you didn't. You heard it. You heard it in the media, right? So jurors might confuse where those bits of information are coming from. Also, pretrial publicity often elicits emotional responses, which are associated with jurors' verdicts. During a trial, you're not going to hear from the victim's family members about you're not going to be seeing the victim's family crying and saying how upset they are and how much they miss the person and all that stuff, right? That doesn't happen. During sentencing, that can happen through a victim impact statement that the family gets a chance to address the court, but not during trial, right? But on the news, you're going to see that. You're going to see, the husband or the wife or the partner of this person sobbing and their kids sobbing, and we know how the media, we know what sells: drama and sensationalism. So all of this can elicit very strong feelings in jurors, and potential jurors might go into that trial really hating the defendant. Even if they think that they can be objective, once they start hearing some evidence, those images of the family members crying and the kids sobbing and all that stuff might start eliciting some emotions in there that wouldn't otherwise be elicited, right? So jurors are, to make things even worse, right? Jurors are generally unaware that their opinions might have been biased by this material, right? So this makes sense, that fitting with what we know about people, humans, we're biased, and we often don't know that we're biased, or we often don't know how we're biased, right? That's just who we are as a species. A tenet of psychology is to keep in mind that we're all biased, and we're all often very unaware that we are biased and how we are biased. Okay, so there could be different types of pretrial publicity. Specific pretrial publicity deals directly with the case. So this is case-specific information that's made available prior to trial that can affect the sentiments of jurors in the trial. So this is information directly about the case that's going to take place. Jurors can also be influenced by what's known as generic prejudice. So this is prejudice arising from media coverage of issues not specifically related to a particular case, but thematically relevant to issues at hand. So in this example here, or in this bullet point, I put an example of deviant sexual behavior. So maybe the media is running, well, let's just say the Jeffrey Epstein case, child sexual trafficking rings. This was in the media for quite a long time. Kind of died down a bit, but it sure to pop up again because people who are associated with Jeffrey Epstein will soon be going to trial. So it'll make the news again. But you can imagine that, let's say somebody who was going on trial for a rape, or going on trial for sexual assault, they probably would not benefit, putting it mildly, would not benefit from jurors being exposed to weeks and weeks of coverage about Jeffrey Epstein and child sexual trafficking rings, right? So that would be an example of, say, generic prejudice. Another example might be just what we see in the news now. It's kind of dominated, or it has been dominated, with coverage of protests that have been taking place all across the country. And in some of these protests, the peaceful protests or assemblies devolve into rioting or devolve into some type of violent act taking place. The media is going to, of course, focus on the violence and the rioting, because that's what people want to see, right? That's what sells. So we might see constant news stories about this, and somebody who is going up for, going on trial for maybe assault during a protest, or for vandalism or something during a protest, it is probably not good that the jurors on that case have been exposed to all of this news about violent protests and rioting. So that information is not specific to the case at hand, but it's definitely related, right? So this is what we refer to as generic prejudice. So in some cases, generic prejudice may actually be more problematic than specific pretrial publicity, especially when we're talking about something that's constant. It's just the news is constantly talking about it. So what are some potential remedies? How can we, let's say, overcome the effects of pre-trial publicity, the prejudicial effects of pre-trial publicity? Well, one is to have a continuance, which means that we're going to postpone the trial. Basically, hold off on the trial, let the news cycle calm down, let people memory kick in, and by that I mean their memories tend to fade, so let that process, the fading of those memories, kick in. Let's give it time. Things will settle down. People will forget some details, and then we'll have a trial. Well, I guess that's fine and good if you were given the option of bail or bond, and you were able to afford the option of bail or bond. Otherwise, you're just going to be sitting in jail until whenever the judge thinks it's a good time to hold that trial. Another method is that you could have an expanded voir dire, meaning that you can question people about the extent of their exposure to the pretrial publicity, or you can have a really intense or detailed voir dire process where you're really getting into say, I don't want to say personality tests. You're not giving out personality tests per se, but you might be asking questions that are trying to tap into some of these personality traits and trying to, really delve into whether or not these potential jurors are prejudiced because of that pretrial publicity. So this tends to be the most popular method because delaying a trial, we saw the problem with that when it comes to bail and bond. But also, you have a right to a speedy trial, right? So, how long are we going to wait for that? I don't know. It's a fine line there. Number three, third remedy is judicial instructions. Basically, the judge will just say, don't pay attention to anything that you didn't hear in this courtroom. So anything you heard on the news or on Facebook or on podcasts or something, don't pay any attention to that. Okay, all the research shows that all of these techniques actually are largely ineffective. But certainly when it comes to judicial instructions, this is me telling you, don't think of a pink elephant right now. Whatever you do right now, don't think of a pink elephant. Just the fact of me telling you not to think of a pink elephant is going to make you think of a pink elephant, right? So telling jurors not to think of that all that pretrial publicity that they were exposed to might actually have the complete opposite effect. So the research shows that these 3 remedies are largely ineffective, which basically leaves the last option, which is a change of venue, meaning you need to move the trial. You need to move the trial to a different county, or sometimes a different state, right? But a different jurisdiction. So you would move the trial to a place where the potential or the prospective jurors were not exposed to as much pretrial publicity, or maybe even to a place where they weren't exposed to any pretrial publicity. So a lot of these crimes that we're talking about might get a lot of local news coverage, and maybe very little national news coverage. So judges are very hesitant to grant a change of venue. It costs money. It clogs up the court system, and it's taking the trial outside of that particular judge's jurisdiction, which, you know, a lot of judges might not be happy about that. But research suggests that this is probably the most effective, if not really the only effective remedy to pretrial publicity, is a change of venue. Move it out of that jurisdiction. Okay, that's the last slide for this lecture. I dealt with jury selection and jury representativeness. So hopefully we learned some interesting stuff, and hopefully we learned some things that might be useful when it comes to the mock trial. So I will see you all next time for the next lecture. Until then, be well. Take care.